Supreme Court in the matter of State of Madhya Pradesh versus Shyamlal dismissed the appeal and stated that in all major high courts in our country there is huge pendency of criminal appeals against conviction and acquittal. Considering the pendency of very old criminal appeals, priority is usually given to the hearing of appeals where accused are in prison. The appeals against conviction where the accused are on bail take a backseat. However, a right balance has to be struck by taking up for hearing even some of the old criminal appeals against conviction where accused are on bail. The old age of the accused and long lapse of time from the commission of offence can always be a ground available to give some priority to the appeals against conviction of the accused on bail. If the appeals against conviction where accused are on bail, and especially where a life sentence has been imposed, are heard after a decade or more from its filing, if the appeal is dismissed, the question arises of sending accused back to jail after a long period of more than a decade. Therefore, it is desirable that certain categories of appeals against conviction where accused are on bail should be given priority. In the present case, Supreme Court said that we are conscious of the fact that there is no appeal preferred by the accused, but the fact remains that medical evidence creates a serious doubt as to whether injuries allegedly inflicted by the respondents caused the death of Lakshman. Therefore, there is a serious doubt whether even Section 304 of IPC could have been applied, as the medical opinion does not support the theory of homicidal death of the deceased. That is why it is not permissible to interfere with the judgment of High Court directing that respondent accused should be let off for the offence under section 304 read with section 149 of the IPC on the sentence that has been undergone. As noted earlier, when High Court decided the appeal in 2017, incident was already 28 years old. When we are deciding this appeal of the year 2024 rising out of a specially petition of 2018, the incident is almost 36 years old. When the judgment of High Court was delivered, at least 5 accused were above 70 years of age and one of them of the age of about 80 years. A substantial amount of 16,000 each has been imposed by High Court by way of fine. Therefore, Supreme Court said it will not be appropriate to interfere with the impugned judgment of the High Court in this case.